Sexual harassment is illegal and not tolerated in New York workplaces. Employees in New York State are protected by both state and federal law. The New York Human Rights Law protects every employee in the state from sexual harassment, regardless of the size of their employer. And Title VII of the Civil Rights Act of 1964 protects workers in organizations with 15 or more employees from sexual harassment, defined as sex discrimination. Additionally, employees in New York City who work for employers with 15 or more workers have added protections under the New York City Human Rights Law. The state of New York has a long history of protecting the rights of every employee, and every employer in the state is required to have a zero-tolerance policy toward sexual harassment. This means that every complaint or known instance of sexual harassment will be taken seriously and investigated, and when warranted, perpetrators will face disciplinary action up to and including termination. Managers and supervisors are held to a higher standard and must always model appropriate behavior. Employers are always strictly liable for sexual harassment committed by owners, managers, and supervisors who have control over the working conditions of the victim. This means that even when employers had no knowledge of sexual harassment occurring, they are still liable when it is perpetrated by managers and supervisors. There are two types of sexual harassment: quid pro quo and hostile environment. Quid pro quo occurs when a manager or supervisor withholds or awards job benefits on the basis of sexual favors. This includes work assignments, hiring, termination, promotions or demotions, positive or negative performance reviews, or any other job-related benefit. Managers and the organizations they work for can be held liable even if a threat was not carried out or if a threat was only implied. For instance, a manager who suddenly blocks a subordinate employee's promotion after that employee asks the manager to stop rubbing her shoulders could be guilty of quid pro quo sexual harassment, even though there was no verbal threat of adverse employment action. Enduring harassment as a condition of employment is another form of quid pro quo harassment. This type of harassment is often seen in office romances. However, there is a fine line between consensual and non-consensual in a relationship between a manager and a subordinate employee. In these situations, the subordinate employee can be made to feel that engaging in the relationship is necessary to remain employed. Even if this was not the manager's intention, it's the perception of the employee that is most important to the courts. Enduring sexual harassment as a condition of employment even occurs when the manager is not the harasser. For instance, it's unlawful for a restaurant supervisor to tell employees to put up with lewd comments and inappropriate touching because it's part of the job of being a server. The best way to avoid quid pro quo sexual harassment is to make objective, job-related personnel decisions and keep personal and professional lives separate. At work, every decision should be made based on job-specific criteria. Quid pro quo sexual harassment is a serious offense, and just one instance is usually sufficient for a plaintiff to win a lawsuit. One single mistake could end a manager's career. Hostile environment sexual harassment consists of words, signs, jokes, pranks, intimidation, or physical violence that are of a sexual nature and that are directed at an individual because of that individual's sex. Additionally, sexual harassment consists of any unwanted verbal or physical advances, sexually explicit derogatory statements, or sexually discriminatory remarks made by someone in the workplace, which are offensive or objectionable to the recipient, cause the recipient discomfort or humiliation, or interfere with the recipient's job performance. While a single, isolated incident does not generally rise to the level of illegal harassment, particularly severe actions, such as the touching of an intimate body part, can be illegal the first time they occur. Sexual harassment does not need to be sexual in nature. Harassment, discrimination, or bias based on gender, gender identity, transgender status, and gender dysphoria are covered under sex discrimination, regardless of whether the harassment was sexual in nature. Additionally, employees are protected against harassment or discrimination based on pregnancy, childbirth, or medical conditions related to pregnancy or childbirth. Hostile environment sexual harassment can occur between employees of the same sex, between employees of different sexes, and between employees of any rank or position in an organization. Harassing jokes, comments, or other behavior can create a hostile work environment, even if they aren't directly targeted at the individual making the harassment complaint. Sexual harassment doesn't just happen between coworkers. The law covers harassment between employees and non-employees who work in the workplace. Non-employees include unpaid interns, independent contractors, and employees who are contracted from third-party companies to provide services in the workplace. Additionally, harassment can be perpetrated by third parties like vendors, facility security workers, visitors, and even customers. Lastly, New York State specifically protects domestic workers from harassment. Sexual harassment can occur anywhere that employees represent their organizations, including work parties, dinner with clients, conferences, trade shows, sales calls, and charity events. Unlike federal law, which requires illegal sexual harassment to be severe and pervasive, New York law only requires that inappropriate behavior subject the victim to inferior terms, conditions, or privileges of employment. The courts use the reasonable person standard when determining if offensive conduct is illegal. In other words, would a reasonable person find the behavior severe enough to subject the victim to inferior terms, conditions, or privileges of employment? The following acts are specifically listed by the New York Division of Human Rights as potentially illegal, or have been listed as part of successful litigation in New York State. Rape, sexual battery, molestation, or attempts to commit these assaults. Threats, intimidation, or physically blocking a person's movement or ability to work. Vandalism of personal or professional property, or other sabotage of an individual's work or ability to do his or her job effectively. Intentional or unintentional physical conduct, which is sexual in nature, such as touching, pinching, patting, grabbing, or either brushing against or poking another employee's body. Requests for sexual favors accompanied by implied or overt threats concerning the victim's performance evaluation, a promotion, or other job benefits. Subtle or obvious pressure to engage in unwelcome sexual activities, unwanted flirting, or repeated requests for dates. Sexually oriented gestures, noises, remarks, jokes, or comments about a person's physical attributes, sexuality, or sexual experience, which are sufficiently severe or pervasive to create a hostile work environment. Yelling, name-calling, and bullying. Long stares and sexually suggestive looks. Gossiping or spreading rumors about sexual topics, or engaging in sexual conversations that are overheard by others. Displaying or posting pictures, posters, calendars, graffiti, objects, promotional material, reading materials, or other materials that are sexually demeaning or pornographic. Sending sexually explicit texts, emails, or instant messages. Viewing sexually based websites and the use of social networking sites for sexually based messages, pictures, or videos. The use of demeaning or offensive names such as honey, sweetie, hottie, baby, girl, boy, or hunk. Offensive gender-based comments or behaviors that demean people simply because of their gender, such as a woman's place is in the kitchen, not the boardroom. Stereotyping people because they don't conform to a gender stereotype, or because they work in a job that has been traditionally held by another gender. What is the manager's role in preventing harassment? Under New York law, managers and supervisors are responsible for sexual harassment they knew about or should have known about with reasonable care and attention and did not do enough to stop. A manager's actions are the single most important factor in preventing harassment. Managers have the dual responsibility of modeling appropriate workplace behavior while ensuring that their subordinate employees behave appropriately as well. This means that managers and supervisors must carefully follow every aspect of their employer's policy, watch for unreported harassment, and ensure that all employees have their legal rights respected. As a representative of their company, managers should make sure that all New York laws are followed. Every employee must receive a sexual harassment policy once a year and within 30 days of hire. This policy must detail the organization's harassment complaint procedures. Managers and supervisors must make sure that their subordinate employees receive and understand the sexual harassment policy and the options available for filing complaints. Employers in New York City are required to conspicuously display an anti-harassment poster and give new employees a sexual harassment information sheet designed and made available by the New York City Commission on Human Rights. Every employee in the state of New York must receive sexual harassment training within the first 30 days of employment and once a year thereafter. Managers and supervisors have a duty to ensure that all of these legal requirements are adhered to within the group they manage. Giving employees a reasonable opportunity to file a complaint and taking prompt and effective corrective action when harassment is discovered are two of the most important factors considered by the courts when determining employer liability. Conversely, employers who fail to follow their policy run the risk of being liable for all acts of sexual harassment. Because employers have a duty to stop harassment before it becomes illegal, employees should be encouraged to report incidents of inappropriate behavior as soon as it occurs. Incidents of quid pro quo harassment and severely inappropriate actions, such as the touching of an intimate body part, threats, or intimidation, must be reported immediately. When employers receive a sexual harassment complaint or otherwise know of possible harassment, they are required to conduct a prompt and thorough investigation. The state of New York suggests 30 days as a reasonable time period to complete an investigation. When a manager or supervisor has knowledge of sexual harassment, it is considered to be the knowledge of the employer as well. Therefore, it's critical that managers and supervisors immediately report sexual harassment complaints or any other knowledge of harassment to their employer. Every complaint must be reported, regardless of the manager or supervisor's opinion on its validity, and even if the employee filing the complaint asks for it not to be reported. The same is true of harassment that managers and supervisors know about or have observed. Even if no one is complaining or objecting to the behavior, it must be reported. Managers and supervisors who fail to report a complaint or knowledge of sexual harassment will be subject to disciplinary action up to and including termination. Employees in the state of New York are required by law to cooperate with management in sexual harassment investigations. Assure employees that all sexual harassment complaints will receive a prompt and thorough investigation, and the perpetrator or perpetrators will be told to stop immediately. Employees who continue inappropriate conduct after being told to stop are subject to increasingly serious forms of discipline, up to and including termination. If a complaint is ignored, employees are encouraged to report the harassment to another person in the organization, as outlined in the sexual harassment policy. Every employee involved in a harassment complaint must be given as much confidentiality as possible. However, warn them that in the process of an investigation, some information will be revealed to others involved with the case. Although some information must be divulged in the process of investigating complaints, confidentiality is guaranteed to the greatest extent possible. In addition to filing a complaint with their employer, employees have the right to file a complaint with the New York State Division of Human Rights within 3 years, or the U.S. EEOC within 300 days of the harassment. Individuals who do not file a complaint with the Division of Human Rights have 3 years to sue directly in state court. Once a suit is filed in state court, a complaint may not be made to the Division of Human Rights. A complaint must be filed with the EEOC before filing a lawsuit in federal court. Complaints filed with the Division of Human Rights are automatically filed with the EEOC. Individuals employed in New York City have the additional right to file a complaint with the New York City Commission on Human Rights for up to 3 years. If it's determined that harassment occurred, prompt and effective corrective action must be taken to stop the behavior and make sure it doesn't happen again. Remedies for the victim may include reinstatement, wages for unpaid time off, or restoration of sick leave and vacation time. If job benefits were lost because of the harassment, they should be awarded. For example, if a victim was passed over for a promotion due to harassment, an appropriate remedy would be receiving the promotion and back pay equivalent to what would have been earned in the new position. In many cases, employers must make changes to policies and procedures to ensure that the harassment does not reoccur. Sexual harassment involving the physical touching of an intimate body part, coerced physical confinement, and/or sex acts may be a crime, and the local police department should be contacted. Bystander intervention is a critical element of sexual harassment prevention. When coworkers speak up, harassment is far less likely to occur. Managers and supervisors must not only encourage, but train their subordinate employees on how to intervene when they witness sexual harassment. Bystander intervention does not have to be confrontational. Talking to an individual in a private setting and in a calm, non-confrontational tone is usually a more effective approach. Rather than condemning the individual's behavior, ask questions. For instance, did you know that your comments are offensive to some people in the office? If the situation warrants immediate intervention, create a distraction. The best intervention is to simply interrupt and ask the victim for help with something in another area. Speaking to the target of sexual harassment is also critical. Victims often feel isolated and afraid and may need help filing a complaint. Bystander intervention may save a coworker from being harassed or assaulted and save many others from future harassment. It's illegal to retaliate against employees for making or participating in a harassment complaint. The New York human rights law protects any employee who has participated in a protected activity. A protected activity occurs when an employee has filed a formal written complaint of sexual harassment, either internally with management or human resources, or with any anti-discrimination agency, testified or assisted in a proceeding involving sexual harassment, either in a court of law or before the Division of Human Rights, opposed sexual harassment by making a verbal or informal complaint to management, or by simply informing a supervisor or manager of harassment, complained that another employee has been sexually harassed, or encouraged a fellow employee to report harassment, opposed discrimination in any manner. Retaliation consists of an adverse action or actions taken against the employee by the employer. Retaliatory actions do not need to be job-related or even occur in the workplace. Unlawful retaliation can be any action more than trivial that would have the effect of dissuading a reasonable worker from making or supporting a charge of harassment or any other practices forbidden by the law. Retaliation can even occur after the individual is no longer employed by the organization, for instance, giving an unwarranted negative job reference for a former employee. Adverse employment actions are not automatically retaliatory. Employees are still subject to regular disciplinary rules and job requirements and must substantiate retaliation claims. If, after an investigation, complaints are found to be without merit, participants are still protected from discipline or punishment if they had a good faith belief that harassment or retaliation occurred. However, the retaliation provision is not intended to protect persons making intentionally false charges of harassment. Warn all employees involved in the case that retaliation is illegal and will not be tolerated. If the accused employee and the complainant work in the same department, separate them until the investigation is complete. Make sure the complainant is not given an unwanted job transfer or less desirable work assignment to avoid retaliation charges. Both harassment and retaliation can result in disciplinary actions, including written warnings, suspension, demotion, and termination. Sexual harassment often affects future career advancement and may even hamper the ability to be hired by another organization. The loss of personal reputation and trust with coworkers, friends, and family can be devastating and life-altering. What can you do to prevent sexual harassment? It's simple. Leave sexually based behaviors at the door. Treat everyone with respect. Speak up when you witness harassment. Every employee deserves a safe, comfortable environment at work. A workplace free of harassment and fear and full of respect. It's up to everyone to do their part in preventing harassment.